Good evening, everyone. This is Dr. SHYAM from XLRI. I welcome all of you to this webinar, this edition of webinar organized by the Jesuit Resource and Response Hub, which is associated with the Indian Social Institute in New Delhi. And today we are going to discuss on the theme Labor Law and Governance Changes in India, a Decent Work Perspective. And I welcome all those who have registered and who are online. And I also take pleasure in welcoming the panelists on your screen, Advocate RAMAPRIYA GOPALAKRISHNAN, Professor RADHICKA KAPOOR, and Ms. Christine Nathan. And I shall make appropriate remarks about them as we go, as I make the introductory remarks. But before I make the introductory remarks, I would like to inform all of you that please feel free to send your comments, your specific questions, and we would encourage you to ask specific questions, preferably addressed to the panelists concerned on your chat box. And if you have any technical issues, kindly type them so that the control room could address them. I'm sure all of us are audible and visible. If there are any audio or video hassles, please send the chat, communicate the same through your chat box. And I thank the Indian Social Institute for organizing a series of webinars, and there's a third in line, I think, and I feel very privileged to act as a moderator to this session, and I'm having a wonderful panel, and I will be having an occasion to speak about them. Let me start making my introductory remarks. And as I said, we are going to discuss on the labor law and governance changes in India, decent work perspective, because we are going to look at the entire gamut of labor law reforms that have been occurring in the last few months, as well as before, keeping in mind the Constitution of India as well as the ILO perspective of decent work. So, labor laws in any country, any pluralistic democratic country is usually, they are drawn from two sources. One is the constitution of the country, and secondly, the international treaty to which the country is a signatory. In the case of labor laws, we have the International Labour Organization, founded immediately after the World War I as a result of Treaty of Versailles in 1919. The International Labour Organization has just completed its centenary in 2019, and over the 100 years, it has constructed a body of treaties, paradigms, and various other protocols and other instruments. Broadly, we would call them as the International Labour Standards Framework and the Decent Work Paradigm. And India was a founder member of the ILO, thanks to its colonial origin. And soon after its independence, it, over a period of decades, constructed an elaborate legal framework comprising central and state labor laws, because labor happens to be in the concurrent subjects as a concurrent in the concurrent list of the Constitution, drawing primarily and hugely significantly from, as I said, the Constitution and the International Labour Standards framework. And these labour laws were to govern the industrial relations system, and that has been so for the past so many decades. Since 1991, India has launched the economic reforms package, and along with the economic reforms package came the argument that the labor laws, which were basically designed for the command economy, need to be reformed or redesigned, suiting the globalized, liberalized economic environment. So over a period of 1992 and 2020, the central government and the state governments have been concerned with initiating the labor law reforms. And from 2015 onwards, the National Democratic Alliance government, led by BJP, has been involved in coding the so-called numerous labor laws, 44 central labor laws in 4 codes. The code on wages, which has been gazetted in August 2019, the code on industrial relations, the code on social security, and the code on occupational safety and health and working conditions. In the meanwhile, since the labor is on the concurrent list, the state governments had also started making changes in the labor laws. And recently, the Rajasthan government, since 2014, has initiated certain significant labor law reforms. When this national and state labor law reform process has been going on, suddenly we have this COVID-19 striking us like a bolt from blue. And on March 24th, the NDA government, the Prime Minister, clamped on us the national lockdown for a long period. The national lockdown has put millions of lives and livelihoods in serious danger, and owing to governance deficits, the national lockdown has caused tremendous amount of pain and loss to the workers, people, and also industry and business. And of course, we have been witnessing considerable amount of litigation in various high courts and also the Supreme Court on the issues arising out of the national lockdown, particularly the wage and employment security interests of the workers, and of course, the right to conduct business for the industry. In the meanwhile, seizing the COVID-19 crisis as the right time, several state governments, starting again from Rajasthan, have introduced changes in the labor laws and the labor inspection system without any consultation with the stakeholders, primarily the trade unions. And to put the record straight, 12 state governments had extended the maximum hours of work by amending the Factories Act 1948, of which 4 have withdrawn. Rajasthan, Punjab on the one hand, and Uttar Pradesh and Karnataka on the other have withdrawn the amendments made to the Factories Act. Uttar Pradesh and Karnataka have withdrawn due to litigation by trade union in the respective high court jurisdictions. And a couple of them, like Madhya Pradesh, Goa, have sought to tinker with the labor inspection system also. While Madhya Pradesh has affected major amendments to the Industrial Disputes Act and the Factories Act, primarily for factories that will be registered or it will be in operation in the next 1,000 days, the Uttar Pradesh government, in an unbelievable move, shocking move, has suspended wholesale operation of some 34 labor laws and substantially amended or diluted the Factories Act, the Building and Other Construction Workers Act, among others. Gujarat is reported to have followed the UP model, but we do not have their blueprint. Now, these changes by the state governments pose considerable, very serious questions. On the one hand, the national process of codification of labor laws is going on. On the other hand, the state governments are making labor law changes. I would not call them as reforms, because reforms have a positive connotation. And then what do the trade unions do? What do the workers do? The trade unions have lodged a complaint with the International Labour Organization, and of course there are 2 or 3 petitions which are before the Supreme Court challenging the UP and MP changes in the labor laws. And it is very significant, I must tell all the people who are listening, that the Director General of ILO, Mr. Guy Ryder, thought it fit to write a personal letter, make a personal correspondence to the Prime Minister of India, Mr. Narendra Modi, in which letter he has requested the Prime Minister for an official commitment of the labor laws to the international treaties that India is signatory to and are bound by. On the other hand, the chairman of the Parliamentary Standing Committee has written to the state government demanding an explanation on dilution of labor laws during the ongoing COVID period, when the Parliamentary Standing Committee is ceased of visiting the courts that have been placed in the Parliament. So it is in this context that we need to ask certain questions, and these questions will probably be answered or addressed by the eminent panelists. Are changes in and suspension of labor laws affected by states in consonance with are they in consonance with the Constitution of India and the ILO treaties and paradigms? The second issue, should the codes be reviewed in the light of COVID-19, and if so, what would be the thoughts of the panelists on these? Thirdly, often the lawmakers emphasize that labor institutions and especially labor regulations impose rigidities on the working of the free market forces, and hence they must be liberalized to attract investment, induce growth, and promote employment. How valid these arguments are? There are, on the other hand, the institutionalists argue that the economic impulses for investment and growth lies elsewhere and not on labor regulation. In other words, labor regulation is not a major irritant or an obstruction for investment inflows. Now, where do we stand? What does the research evidence say? We would like to hear from the panelists. Fourthly, what would be the impact of these reform measures on the employment and income prospects for workers, especially in the informal sector, the precarious workers, and the migrant workers? Fifthly, what are the strategies and plans of the trade unions to confront these disruptive changes? Much of the crucial reforms that have taken place at the regional level have been done without any social dialogue. How do the central trade unions propose to counter these sub-national reform strategy? And I find it a very disturbing question, because India is a signatory to International Labour Organization's Convention C-144, that is Tripartite Consultation Convention 1976, which requires the government of India and the state governments to consult trade unions before, on issues concerning social, labor, and economic policies. I note with tremendous concern as a social scientist that the social dialogue forums in India have been largely ignored. So what do the trade unions do? We know that the trade unions went on a strike on a couple of occasions during COVID times, notwithstanding the lockdown. And the 10 trade unions proposed to go on strike in the month of July. Now, are these strikes an answer to call the government to dialogue table? Or should the trade unions do something better? And what will be the impact of ILO intervention? What can the trade unions do in order to complement the intervention made by ILO? And even though trade unions are fast becoming inclusive, can the extent of union coverage of informal and migrant workers, could they be higher than what they are? Some rough estimates worked out by me suggest that not more than 50, a generous estimate of union coverage in India, macroeconomic estimate could be not more than 15% of union coverage, which leaves a large amount of workers unorganized. And finally, we have two kinds of development models. One is the neoliberal development model that has come. On the other hand, we have the institutional decent work development model. The decent work development model is an inclusive growth model, social dialogue oriented model, high labor standards oriented model, and which befits pluralistic and democratic countries. On the other hand, we have the neoliberal model, which is low labor standards model, cheap labor cost model, and a model which is prepared to sacrifice labor rights at the altar of economic growth. So we have the two competing paradigms. One is the ILO's decent work, people-centric model, I would call it. In fact, the Future of Work Declaration also emphasized that economic and labor and social policies must be people-centric. And that is what the Future of Work Declaration, to which India is a signatory. On the other hand, we have the neoliberal model, which is being aggressively pursued by not only the central government, but also by the state governments. So on the one hand, we have a kind of a long-standing problem posed by the neoliberal model, a kind of an institutional sclerosis, institutional dilution. On the other hand, the COVID-19 has been exploited, even unethically by the government, to push down undesirable and a very disastrous labor deregulatory model. So where do we go? These are some of the thoughts that have come to my mind, which I am sharing not only with the panelists, but also with the larger audience. And I'm sure these issues will be addressed by my fellow panelists, and they are worthy of concern. And of course, the debate will go on. And it is in this context I must thank again ISI for agreeing to host this webinar and flag these issues of considerable social political concern. And I shall stop here, and I request Advocate RAMAPRIYA Gopalakrishnan to start making a presentation, and each panelist will be having 20 minutes to make their presentations, and I shall come at the end. Over to you, madam. Thank you.
Good evening, everybody. Am I audible?
Yeah, you are audible. Yeah.
Yes. Good evening, everybody. First of all, I would like to thank Dr. Denzel Fernandez for inviting me to this webinar. I also wish to thank SHYAM Sundar, Professor SHYAM Sundar, the moderator. Now, this evening, I'll be taking you through the labor law changes announced by various state governments in the wake of the COVID-19 crisis and the prolonged lockdown. I'll be also taking you through the implications of these changes briefly and then discussing the legality of the changes. But before I start discussing what the changes are, I mean, in a nutshell, Professor Shyam Sundar has already taken you through the changes. I would like to give you a bit of the context. That again is something he has done, but again, I would like to go back to the context in which these reforms are being made. Now, since 2014, the central government has been announcing a series of changes to the labor laws. These are aimed at affording greater flexibility to employers in the matter of hiring and firing workers, in the matter of wages, in the matter of remitting social security contribution, in relation to the conditions of work. So basically, the whole idea behind this reforms agenda is to afford greater flexibility to employers and also to whittle down labor inspection. That is also one of the key items on the agenda. But what is central to this whole labor law reforms project? I put labor law reforms in quotes because, as Professor Shyam Sundar pointed out, labor activists and trade unions take very exception to the word reforms because they say the word reform should mean some positive changes to the laws. But what is happening in the name of reforms is whittling down of existing protection and undermining of existing protection that workers have under the labor laws. So they take very exception to the very term labor law reforms. Now, the central to the labor law agenda, or the pet theme of the labor law reform agenda, is the codification of the 44 central labor laws into 4 codes: the Code on Wages, the Code on Industrial Relations, the Code on Social Security, and the Code on Occupational Safety, Health, and Working Conditions. The Code on Wages has already been passed by both houses of parliament and just become law. The other 3 codes are still now in the draft stage. The central government has not been able to push through the codes at the pace at which it would have liked because of the stiff opposition put up by the trade unions. So it has not been able to push these codes through the parliamentary process. And in the meanwhile, from March, the COVID-19 crisis came up this year, and on March 25th, the nationwide lockdown has been imposed. And taking advantage of the lockdown, or rather using the lockdown as a pretext, various state governments have taken it upon themselves to take forward the unfinished agenda of the central government. And various state governments have announced major changes to the labor laws of the country, making use of their concurrent powers. And the changes can be broadly classified into 4 categories. So one type of change is extension of the daily and weekly hours of work. The other type of change is exemption from various labor laws. The third type of change is increase in the threshold for the application of labor laws. And the fourth is exemption from labor inspection. Now, exemption from labor inspection. Now, I'll take you through each of these 4. Extension of daily and weekly hours of work. Under the Factories Act, a worker ought to work for a maximum of 48 hours a week and 9 hours a day. Inclusive of overtime, a worker cannot work for more than 60 hours a week. This is what the Factories Act provides for at present. Now, 12 state governments, earlier it was 15, now 3 of them have retracted, so right now it's 12, have increased the daily and weekly hours of work. Over the last couple of months, they've increased it from 8 hours a day to 12 hours a day. That is an additional 4 hours a day. And they've increased the weekly maximum working hour limit from 48 hours to 72 hours. So obviously, this would affect the work-life balance of workers. This would leave workers fatigued and exhausted, and this would endanger the health and safety of workers. This aspect seems to have been entirely overlooked. Now, this change, it is obviously in violation of Article 21 of the Constitution of India. Article 21 guarantees the right to life. The Supreme Court has expansively interpreted Article 21 to include a host of other rights, including the right to health of workers and the right to just and humane conditions of work. Now, unreasonably extending the hours of work to 12 a day and 72 a week, it is obviously in violation of the right to health. It's obviously in violation of the right to just and humane conditions of work, and consequently, it is in violation of the right to life protected by Article 21. Now, this is also, such extension of the hours of work is also in violation of the Hours of Work in Industry Convention of 1919, the very first convention of the ILO which India has ratified. This convention stipulates a maximum daily limit of 8 hours of work and a weekly limit of 48 hours of work. As a temporary exception, in cases of force majeure, it allows for an additional 1 hour of work a day. So assuming the increase had been made only to 9 and over a period of 3 weeks, if the 48-hour limit was still was still maintained, it would be in accordance with convention number 1, but this is not what has happened. What has happened is an unreasonable increase in the amount of, in the limits of daily and weekly work, which is not in conformity with convention number 1. So the extension of daily and weekly hours of work is in violation of the fundamental rights. It's in violation of international labor standards that India is expected to give effect to. Now, the second kind of change is the exemption from various labor laws. Now, 3 states have gone in for this kind of exemption. The most glaring case is that of Uttar Pradesh. Uttar Pradesh is in the process of promulgating an ordinance called the Uttar Pradesh Temporary Exemption from Certain Labor Laws Ordinance. If this ordinance were to become a law, it would mean that in factories and other manufacturing establishments in the state of Uttar Pradesh, for a period of 3 years, none of the labor laws will apply, with the exemption of the Bonded Labor System Abolition Act, the Employees Compensation Act, the safety provisions in the Factories Act, the safety provisions in the Building and Other Construction Workers Act, Section 5 of the Payment of Wages Act, which basically sets out the time within which wages should be paid. And another exception is the provisions in the labor laws relating to women and children. The ordinance provides that the minimum wages should be paid. Now, what would be the implications of this ordinance? What would be the implications if, but for the laws which I just mentioned, if factories and manufacturing establishments were to be exempted from all labor laws for a period of 3 years? It means that for a period of 3 years, if this ordinance were to be promulgated, none of the laws relating to industrial relations, namely the Trade Unions Act, the Industrial Disputes Act, and the Industrial Employment Standing Orders Act, would be applicable in the state of Uttar Pradesh for a period of 3 years to factories. Then the laws relating to wages, such as the other provisions of the Payment of Wages Act relating to unauthorized deductions, they will not apply. The Payment of Bonus Act will not apply. Then it also means laws relating to working conditions, such as the Contract Labor Act, the Interstate Migrant Workers Act, the Weekly Holidays Act, and so on, they will not be applicable. Then laws relating to occupational safety and health, such as the Dangerous Machines Act or the Boilers Act, will not apply. And then the social security legislation, such as the Payment of Gratuity Act, the Employees Provident Fund Act, and the Employees State Insurance Act, will not apply for a period of 3 years. So what would be the implications of this? The implications of this would be that it would be very easy for employers to get rid of the entire permanent workforce and hire and have an entirely precarious workforce. The workers can be terminated arbitrarily even without paying any compensation to them. It also means that workers cannot register trade unions. Workers cannot exercise their freedom of association and collective bargaining rights. They cannot raise demands of the management for better working conditions. It also means that employers need not pay fair wages, let alone living wages. They can get away by paying the minimum wage, and workers cannot demand a fair wage. Then it also means that if the health provisions of the Factories Act and the Building and Other Construction Workers Act will not apply, it means that employers need not even provide basic amenities like drinking water, toilets, and canteens for their workers. It also means that the provisions relating to labor inspection will not apply. And then it means that workers will not have any avenue for grievance redressal. They cannot raise industrial disputes. They cannot take their disputes either for conciliation and adjudication. So it would lead to a very inequitable and imbalanced situation where the workers are left with no power, no ability to resist any injustice, whereas the employers would have total flexibility and a total free hand to do as they please. Now, is this in accordance with the Constitution of India? Very obviously, no. This again would violate the right to just and humane conditions of work, and the right to health protected under Article 21 of the Constitution of India. Now, this would also be contrary to the international labor standards protected under Convention 87 and 98. Now, I know some of you may immediately wonder, India has not ratified these conventions. But even though India has not ratified Conventions 87 and 98, nonetheless, it is expected to give effect to the principles and rights contained in this convention by virtue of its very membership of the ILO, as a result of which it's bound by the constitution of the ILO. And these, and also by virtue of the ILO Declaration on Fundamental Principles and Rights at Work of 1998, the government of India is expected to respect, promote, and realize the rights and principles contained in conventions number 87 and 98, regardless of the fact of its non-ratification of the conventions. Now, also, if this, in the state of Uttar Pradesh, this ordinance is promulgated, it would also mean that workers can be arbitrarily terminated. Their occupational safety and health rights will not be need not be respected, and labor inspection will be whittled. Whittling down of labor inspection will be contrary to ILO Convention number 81, which again the government of India has ratified. And India has also ratified certain occupational safety and health conventions, such as the Maximum Weight Convention and the Benzene Convention, for example. Again, if labor laws will not apply to factories in Uttar Pradesh, it would also be in violation of these conventions. So exemption from labor laws is again in violation of the fundamental rights and also in violation of international labor standards. Now, Madhya Pradesh again has proposed 3 kinds of exemptions. It has proposed, no, it's actually already amended the law so as to ensure that the Industrial Disputes Act will not apply to new industries in the state for a period of 1,000 days. It has exercised its power under 36B, which is of the Industrial Disputes Act, to afford such exemption, which itself is questionable in the first place, because Section 36B is intended to apply only to government undertakings, where an alternative effective dispute resolution mode is in place. It is not intended to apply to all undertakings across the board. But anyway, the government of Madhya Pradesh, in the exercise of its power under Section 36B of the Industrial Disputes Act, has exempted new industries from the application of the provisions of the Act, except those relating to layoff, retrenchment, and closure. Which again means that for a period of 1,000 days, workers in new industries will not be able to exercise effectively their freedom of association and collective bargaining rights. This is because they won't have any protection against unfair labor practices or any protection against acts of anti-union discrimination and acts of interference. So they cannot effectively exercise their freedom of association and rights. And also, if the other provisions of the Industrial Disputes Act will not apply, it means that they will not be able to enter into negotiations with the employers in respect of wages and other conditions of work. Now, the government of Madhya Pradesh has also exempted 11 kinds of industries from the Madhya Pradesh Industrial Relations Act. This is a legislation which provides for recognition of trade unions. It also provides for avenues of grievance redressal. Now, it means the workers in these 11 kinds of industries will not be able to take up their disputes for conciliation and adjudication. It also means that workers cannot demand recognition of their trade unions. This again affects the exercise of collective bargaining rights. So in the state of Madhya Pradesh, again, as a result of these changes, the rights and principles and rights protected under conventions number 87 and 98 that India is expected to respect and observe have been given a go-by treatment. And this is in violation of international labor standards. This is also in violation of the fundamental right to freedom of association protected under Article 19(1)(c) of the Constitution of India. It will also be in violation of the fundamental rights protected under Articles 19(1)(a) and 19(1)(b), because workers will not be able to protest, they will not be able to demonstrate, and these rights are protected by Articles 19(1)(a) and 19(1)(b) of the Constitution of India. Now, Gujarat has again proposed to promulgate an ordinance. We are yet to see the text of the ordinance because it's not out in the public domain. but apparently it's only minimum wages are going to apply. And in Gujarat, apparently this ordinance will apply not just to manufacturing establishments, this exemption from labor laws ordinance, but it's also going to apply to establishments in the service sector, which means that in both the sectors, again, just and human conditions of work and the right to health of workers is going to be compromised on. So it's not in conformity with fundamental rights and the international labor standards. And the third kind of change which certain states have brought about is an increase in the threshold numbers. Now, for example, Tripura, it has increased the numbers for the application of the Factories Act from 10 to 20 in the case of factories working with electric power, and 20 to 40 in the case of those working without electric power. Now, states such as Maharashtra, Andhra Pradesh, and Rajasthan have already made such changes to the Factories Act. Tripura is following suit. But the implication of this change is that a whole lot of manufacturing establishments will be brought outside the purview of the Factories Act. Now, Tripura has also proposed to amend the Contract Labour Act, increasing the threshold numbers from 20 to 50 for the application of the Act, which means now you take the case of an establishment working without electric power, where there are 39 or 38 workers. It will not be covered either by the Factories Act or it will not be covered by the Contract Labour Act, which means that virtually there is going to be no labor regulation applicable to this manufacturing establishment, and that is a very dangerous situation. Again, this is not in accord with the Constitution of India. And the fourth kind of change is exemption from labor inspection. Now, Goa, it has proposed, it has announced a scheme for self-certification, both under the Factories Act and under the Boilers Act. So under both these legislations, regular inspection is not going to take place in the state of Goa because it's going to be substituted by self-certification. And this was not in accord with ILO Convention number 81, which India has ratified. In Madhya Pradesh, the government has proposed third-party certification. Actually, I'm wrong when I say proposed. Already this change has come about. It has allowed for third-party certification in respect of factories having non-hazardous manufacturing processes where less than 50 workers are employed. Third-party certification again cannot be a substitute for regular labor inspection. So again, this is not in accord with ILO Convention number 81 that India has ratified. So as you can see, these changes are not in accordance with international labor standards. They are not in accordance with the fundamental rights. That means that none of these changes will stand the scrutiny of law if they are challenged in a court of law. Thirdly, apart from these standards in fundamental rights, which I already talked about, these changes are also in violation of the commitments that the government of India has undertaken by virtue of ratifying Convention number 144, one of the governance conventions, which is the Tripartite Consultation Convention. One of the recommendations attendant to this convention is recommendation number 113, which requires the government to consult with representative workers and employers organizations before making any changes in the labor laws. Now again, there has been no such consultation prior to these changes being made, and therefore again this is in violation of an important labor standard, the standards contained in Convention number 144. Now, Brother Shyam had asked a question that should the codes be reviewed in the light of the COVID-19 crisis? My answer to that question is no. Any, responses under the law or in policy to the COVID-19 crisis, the responses should be equitable. They cannot compromise on workers' rights. Workers' rights are basic human rights. They are non-negotiable. Any changes that dilute workers' rights cannot be made, and particularly no changes can be made without consultation with representative workers' organizations. So in the light of the COVID-19 crisis specifically, I would say there is no need to review the codes, but there is a need to review the codes to improve on the workers' protection and to universalize the codes and to ensure that these codes apply across the board to all sections of workers, and they contain minimal labor standards that will safeguard the rights of workers in all the sectors. Thank you.
Rama, that was very good presentation, crisp presentation. Before I request Dr. Radhika Kapoor to make a presentation, I just want to say a sentence. The entire sum and substance of RAMAPRIYA's presentation shows that there is in motion a process to suspend industrial democracy, which threatens equity, justice, and dignity. And these changes conform neither to the Constitution nor to the international treaties.
Shyam, can I make one more point?
Please, please.
Yeah, because I think I forgot to make the point about the concurrent exercise of power, which is an important point. So what has happened in the state of Uttar Pradesh is the ordinance making power under Article 213 of the Constitution is sought to be used to bring about the ordinance. And the concurrent power of the state can never be used to do away with central labor legislation and to bring about a vacuum in a field which ought to be covered by labor laws. So the state government may amend central labor laws, that is permissible, but it cannot entirely do away or wipe out the central labor laws. That it cannot do in the exercise of its concurrent legislative power or the ordinance making power. So for this reason also, the labor law changes which are sought to be made by the governments of Uttar Pradesh and the governments of Gujarat, for this reason also they will not stand legal scrutiny. Thank you.
Thank you very much. So, Professor Radhika Kapoor, now we have had the judicial perspective from, legal perspective from RAMAPRIYA, but very often people say that law is one thing and economic markets behave in a different manner altogether. So, as an economist, please throw, I mean, I'm sure we would throw some light on this debate and whether these are in fact justified or not. So over to you, Professor Kapoor.
Good evening. Thank you very much, Dr. Fernandez, Professor SHYAM Sundar, for inviting me to be a part of this panel. It's indeed a pleasure to be a part of this very important conversation. Now, both Professor SHYAM Sundar and RAMAPRIYA have outlined very clearly the nature and the form of changes that we have seen in labor laws over the course of the last month and a half. The exercise started with the process of extending working hours in a few states, and then it went on to take a more drastic shape and form in the ordinance that we saw in Uttar Pradesh, where essentially firms were exempted from labor laws which were dealing with occupational safety, health and working conditions of workers, regulation of hours of work, wages and settlements of industrial disputes. And these are laws which essentially apply to what is called the organized sector of the economy, to registered firms, to formal firms and large establishments in general. Now, ostensibly, the reason for this was to create jobs in the light of the large-scale loss of livelihoods and employment in the wake of the pandemic and the lockdown, and also to attract investment from factories that were exiting China in the face of the outbreak of the coronavirus. Now, these changes actually, they essentially stem from belief that India's labor regulations are inflexible, rigid, and it is the nature of regulations is pro-worker, and that increases labor costs, it increases the cost of doing business, and has adversely affected a range of economic indicators. And this popular belief, this widespread perception, actually emanates from a very vast body of economic literature, which is attributed to the poor performance of India's manufacturing sector to its labor regulations. There's a very large number of papers which have been written on this subject, which have gone on to argue that it is in fact India's labor laws that have reduced output, employment, investment, and productivity, in particular in the formal manufacturing sector, In fact, it's also been argued that they have diverted manufacturing activity to the unorganized or the informal sector, where both productivity and wages are low. Now, in this entire body of literature, I'm going to spend a couple of minutes talking about what has perhaps been the most influential study in this space, which has in turn spawned off an entire body of literature that has corroborated and reiterated this view. There was a famous paper which was written by two economists at the London School of Economics, Tim Pesley and Robert Burgess in 2004, which examined the Industrial Disputes Act, which is one amongst dozens of India's labour laws, which essentially looks at the investigation and settlement of industrial disputes in any industrial establishment. And what their paper did was it basically examined state-level amendments to the Industrial Disputes Act, and it then coded these amendments as being either pro-employer or pro-worker. And they studied the amendments for a period from 1949 to 1992. And then what they found was that there was a negative impact of pro-worker regulations on output, investment, employment, and labour productivity amongst firms in the registered manufacturing sector. And thereafter, there have been several studies which have used this codification exercise of Pesley and Burgess. And in fact, they've modified some of this, some of their codifications, and they have gone on to argue that not only does this codification capture whether amendments were pro-worker or pro-employer, but they also use it to interpret whether the labour regulatory environment in a state is flexible or inflexible. Now, there are several papers which have been written by Professor Aditya Bhattacharjee at the Delhi School of Economics, where he has analysed and studied this body of literature very carefully. And he has pointed to several flaws in this exercise. He's shown, for example, that very few of the amendments that Pesley and Burgess actually looked at in the construction of the index pertain to what is widely understood as whether the labour market regime in the state is flexible or inflexible. And in fact, in some cases, there has also been an error in their codification. And beyond going on to point out serious errors in the construction and the measurement of these indices, he also points to serious econometric issues, which have raised a question mark on these studies. Now, despite the fact that these studies have been questioned, the notion that it is inflexible labour laws that have hurt the growth of the manufacturing sector have dominated the narrative. And surprisingly, there are several other studies that suggest other.
Radhika, 1 minute. Your audio is not really clear. Maybe you have to remove your AirPods and try.
Okay. 1 second.
And also the video is having a problem.
Can you hear me now?
Yeah, it's better.
1 second. Can you hear me?
Yeah, it's better.
Better? Okay. So was I audible at all in the beginning? Do you want me to go back?
Still, it is still slightly. You can make it better.
Okay. How do I do that?
Okay, carry on. I will see how it goes.
Okay, so what I was saying was that this entire body of literature, which has looked at the adverse impact of industrial labour regulations on the performance of the manufacturing sector, has been questioned. And in fact, there have been series of papers which have suggested otherwise, but will not attract much attention in the popular narrative. For example, there's the work of Simon Beacon, who has developed an expert data set in Indian labour laws over the period 1970 to 2006. And in his analysis, he actually finds that pro-worker labour legislation don't lead to unemployment or industrial stagnation. Rather, pro-worker labour laws are associated with low unemployment. Then there's the work of Emmanuel Fiddledom, who actually looks at this codification exercise more carefully, and instead of classifying amendments as being pro-worker or pro-employer, he has reclassified them along a different dimension, which is whether they increase or decrease government intervention in industrial disputes. His econometric results show that more intervention has actually resulted in higher investment, output, and productivity. And this is consistent with the argument he makes in his paper that third-party mediation and institutional settlement of grievances provides an alternative to disruptive forms of protest. The question is not just one of the codification in the literature, but there is also a broader issue of what the labor regulatory regime is de jure and what it is de facto. And in fact, Professor Shamsun has a large body of work on this, where he has said that labor laws in India are actually even a paper tiger. And we have a large number of indicators, statistics which actually corroborate the fact that labor laws, the so-called rigid labor regulatory regime does not bite. For instance, to begin, factories with
Professor Radhika? Professor Radhika?
Yeah.
Sorry to interrupt. I think there is something, maybe you are using an iPad or something that, I mean, the audio is, the audio is very, even I'm not able to catch, and even they are not able to record. And I think maybe you can just revisit your system.
Using a laptop.
Yeah, but somehow the audibility is quite a bit of an issue. So I'm not able to follow, and even others, they have just spoken to me. So what we can do is that I'll now maybe request Kristen to come in, and then in the meanwhile you can think about what exactly is the you can set it right, because yours is a very important part of it, and it has to be. I mean, everyone should be able to hear it.
I'll just do that.
Yeah, thanks for understanding. In the meanwhile,
no problem.
I'm sorry, ladies and gentlemen. There is some technical issue at the end of Professor Radhika Kapoor. She will come back and continue with her presentation. Now, can I request Ms. Christian Nathan to come on board? And only one question following from RAMAPRIYA is that she says that most of these labor law changes will not stand the test of legal scrutiny in the judiciary, in the court of law. So that is one thing that I would request you to respond to. And then, of course, you can. I mean, that is one of the issues that I'm flagging to you. So over to you, Ms. Christian Nathan.
Thank you, Shyam. Thank you for the invitation to participate in this webinar organized by the Jesuit Resource and Response Hub, and particularly to Father Denzel. And particularly that this focus today is on the labor law and governance changes in India. And also thank you for the warm words of welcome. I think let me start with today the workers not only all over the world, yes, but particularly in India, are facing very difficult times. I also would like to thank the excellent background presentation given by Professor SHYAM Sundar, and also RAMAPRIYA, where she gave a good detailed background as to where we are today on the 44 laws turning into 4 labor codes and these urgent ordinances issued by the various states in the country. I think at this point, especially since we're looking at a trade union perspective, I would like to take this chance to discuss and deliberate the trade union's perspective as to what we see are the important issues and priorities today. Number one, what the trade unions are really concerned and looking at is the respect for labor rights. This is a priority. For far too long, we have seen growth through talking about growth only through the lens of economic growth, about investments, about production and industrial output. I think we have been mesmerized a lot by these huge words and by these big banners. I think the call for the workers, without whom these results will not be achieved, as RAMAPRIYA said, and the respect of their rights has been drowned under this loud voice. What is overlooked in this entire changes is the human and trade union rights situation in India, which is really worrying for the trade unions. And RAMAPRIYA and SHYAM have brought this up a couple of times. What is also a concern for the unions now is the growing denial, not only denial, but also abuse of trade union rights. Let us not forget that trade union rights are basic human rights. In India, as we have seen by the earlier speaker, in the past 4 to 5 years, the trade unions have seen the draconian attitude of the government arbitrarily making changes to the labor laws. RAMAPRIYA has made a list of the changes which is going to be looked at the labor laws. Now, participation of workers in these discussions is denied. Unions who have campaigned against these issues, they have been arrested and they have been detained. Now, workers, as we looking, what are the working conditions going to look like? Workers' employment conditions are now not only weakened as a result of informality, which we have more than 94% in India, but these new laws and ordinances of working hours, wages, etc., is going to result in much more informality. There are a number of workers in the informal economy in India. The growing number of formal jobs are now being made informal through subcontracting, and we can see subcontracting is going to play a much major role. Now, this practice is also going to be rampant in the organized sector as well as the unorganized sector. Employers, as said earlier, are simply finding ways to avoid paying for long service leave, gratuity, and other conditions that come with permanent employment. The trade unions in India also want to highlight that there is no discussion held, no consultation held, and the ratified ILO Convention 144 has been violated. Also, the ILC meeting has not happened for quite some time now. The trade unions are desperate and wants the governments to address improvements in industrial relations, but the word reforms is used to abuse what has already been achieved. In particular, the process of collective bargaining. Now, if we do not have trade unions and for 1,000 days they want the benefit of no unions, we can see this will be a further attack on collective bargaining, on union rights, and what we have achieved over the years is just going to be whittled down. The urgent concern today for the trade unions are deprived of the right to establish and join trade unions, which means this 1,000 days of leave from the labor laws is we are not going to have trade unions, and no forum or any anchor where we are bringing our issues, which will lead, of course, to no collective bargaining to negotiate with their employers, whether it's wages, whether it's working hours, whether it's working conditions. I think in the current COVID scenario, under which the government has quickly moved in to attack the labor laws, they are under the constant attack by the government and the employers for some time. And the reason they say they want to change the labor law reform is in the area of attracting foreign investments. Many programs like the export processing zones, the special economic zones, and other business-friendly economic policies, all restrictions are placed on collective bargaining, which really brings us no role for the trade unions in future. It is now restricted further through a set of ordinances announced recently by several states. Looking at the present scenario and the informality increasing, the fear is there will be forced labor and child labor in India will now increase rapidly. Forced labor will also increase in the traditional sectors and also in modern supply chains, in fishing, in electronics, construction work, and domestic work. The other area we also have to look at is the migrant workers, which is a big concern for the trade unions, are employed, as we can see today, in violation of the 1979 law. They're employed under very pathetic conditions, not to talk about what happened to the migrant workers over the last 2 months. Improving their rights and working conditions today is a priority. The low-wage migrant workers today face severe economic exploitation, socially excluded, and political disenfranchisement. They are often denied their freedom of association and right to collective bargaining. The agents who bring them from the rural areas to the cities charge an exorbitant amount of money. And in a way, it is informally bringing in bonded labor. In these trying times, what the unions are really facing, another challenge is how to handle inequality. Inequality is associated with greater wage inequality and a delinking of productivity and wage growth. Productivity is increased, but wage, we can see, has not kept pace with it. Wages are declining today in real terms. This is all we can say due to lack of freedom of association and collective bargaining. Today, the trade unions are constantly reminding the government that independent and free functioning trade unions are institutions of democracy. Collective bargaining is the strongest instrument to ensure equality and a fair distribution of wealth. This is why they want to do away with trade unions and, of course, collective bargaining. Trade unions and practice of collective bargaining is fundamental if we want to build an inclusive future with decent work towards sustainable development and goals. Today, after COVID, the trade unions have started to reflect on some ugly trends in the economy. This is in relation to democracy, in relation to tolerance, and respect of basic trade union rights. Corruption in government, rise of nationalism, mixed with racial discrimination, increase in intolerance based on religion, race, ethnicity, and ethnic cleansing have seen this ugly head rising in the country since a couple of years. Independent and free functioning trade unions are institutions of democracy. Collective bargaining is the strongest instrument to ensure equality and fair distribution of wealth. Trade unions and practice of collective bargaining is fundamental if we want to build an inclusive future with decent work towards sustainable development in India. What are the specific strategies and struggles we look at? Specific strategies are developed on selected priorities, including a campaign for the fundamental conventions, which is particularly 87 and 98. There is a need for a consolidated approach which the unions are looking at to work closely these days with the ILO, with the ITUC, which International Trade Union Confederation, and national trade unions, which is looking at a policy and political environment that enables the realization of fundamental rights. The unions continue to strengthen their capacity building programs for unions to develop their capacity to now particularly to organize and to collect and conduct collective bargaining effectively, participate in the implementation process. The work done by the unions during this period is particularly reaching out, providing transport, food, and in addition to their regular trade union work, this is what the unions are doing. Food and ration distribution, medical facilities, sensitization, awareness campaigns, distributing leaflets and information on the medical issues. Most of all, importantly, today, the unions are inundated with calls and cases on complaints of wages, wage cuts, dismissal, pension issues, non-payment of wages, housing, workers thrown out of their housing quarters. Addressing these concerns for the unions, now their role is they are becoming counselors, to which a lot of workers are now frustrated, helpless, and anxious. There are workers threatening to commit suicide, and violence in the family has increased. Presently, the unions are in regular touch with the national government, with the state governments, and they keep them continuously informed of the crisis the workers are facing. Despite no response, either verbal or written, the struggle and fight has to continue. You have already seen, and SHYAM has mentioned, that the hunger strike organized by the national trade unions over the last couple of years has been held jointly. There's been no reaction. A second strike is now planned for 3rd of July, and if still no reaction comes from the government, the workers will be forced to take to the streets, protest in large numbers, throwing all caution to the winds, unmindful of the consequences. social dialogue. There's also been a campaign recently where the employers were saying that the unions are not interested in consultation. How can the unions not be interested in consultation and discussion? Because that's what they've been fighting for over the last years, and in particular for the last 3.5 months. All the management does, whatever they say, is to make sure that there is a campaign going on to tell people that the unions are not interested in consultation, because the management definitely does not want any role of trade unions, because they feel it's only they will come on strike, their flexibility will have problems, hiring and firing will go into severe problems again, the low labor cost and the low turnover cost. And management does not want any grievance procedure, any grievance handling the role of the trade unions, as they feel that they can deal it directly by the workers. The other area we can also see is that there are wider alliances now being built by the trade unions with academics, with joint platform where all the 10 national centers are on board, with researchers and with universities. What are they doing? What is the role here of ILO and ITUC? The ILO, particularly on this time, has played a very significant role during the current crisis, where the ordinances were announced overnight in the number of states. And as Shyam said, the Director General of the ILO did send a letter immediately to the Prime Minister of India, asking him to withdraw these ordinances, number one. Please look at social dialogue, please consult the stakeholders, and also bringing to attention that you are a member of the ILO, and please remind you the principles of being a member of the ILO, the importance of role of trade union in a democracy, and also reminding India of the various declarations and conventions India has adopted. One of the areas we're looking at is how to, they keep saying social dialogue, but how do you have social dialogue if they are never invited or never even considered as one of the stakeholders in looking at the labor law changes? I think a stable claim must be created where the autonomy and independence of the trade unions and the employers are fully respected in compliance with 87 and 98. And we must look at going back to effective consultation with the national constituents if it is necessary to engage with other partners, including ILO and other civil society organizations. And as I said, the trade unions are in a real dilemma today. Their struggles are because the resources, everything is shut. The workers are in a very tough situation. It's not only the workers, also their families are severely challenged today. And this becomes a very one of the most difficult times, I think, in the history of the trade unions in India. Thank you.
Thank you very much. Thank you very much, Christine. That was a very lucid presentation, and you have emphasized that trade unions are not averse to dialogue, and the onus is on the government and the employers to bring back the social dialogue. Now we will go back to Professor Radhika Kapoor, and over to you, Professor.
Am I audible now?
Yeah, you are audible. But
okay. Is it still unclear?
Little louder, please.
Is it still unclear?
No, you carry on. Let us see. Let us see how it goes.
Okay. So I'm just going to give a quick recap of what I said already.
No, there is a miscue.
Sorry?
Can you speak 3-4 sentences so that we can see? We can find out.
Okay, sure. So what I was saying was that some of the changes that we have seen in the labor law, especially in the states of Uttar Pradesh and Madhya Pradesh, which have exempted firms from labor laws which are dealing with occupational safety, health and working conditions of workers, wages and settlements of industrial disputes, the ostensible argument for this has been that there is a need to create more jobs, and this is the idea of attracting investment from China in the wake of the pandemic. Now, these changes essentially stem from the belief that India's labor regulations are inflexible, rigid, they're pro-worker, they've increased labor costs, they've increased the costs of doing business in India, and this has had an adverse impact on a range of economic indicators. There has actually been a very large body of empirical literature which has supported this belief, which has shown that having rigid labor laws actually reduces output, employment, investment, productivity, entry by new firms in the organized manufacturing sector. And one of the most influential papers in this literature was a paper that was written by Tim Besley and Robin Burgess, which essentially looked at the Industrial Disputes Act, and it analyzed the amendments which were made to the Industrial Disputes Act by several state governments between 1949 and 1992. It described these amendments as being either pro-employer or pro-worker, and then there was a negative impact of pro-worker regulations on variables like output, investment, employment, and so on. And then this paper actually, am I clear now? Can you hear me?
Yeah, you're audible.
Okay. So this paper then went on to spawn an entire body of literature where various researchers used this index that was constructed by Besley and Burgess, and they reiterated the findings of that paper, which showed how rigid and inflexible labor regulations had hurt the growth of the manufacturing sector. Now, more recently, Professor Aditya Bhattacharjee at the Delhi School of Economics has written a paper where he has raised serious questions on the construction of the Besley and Burgess index, which has been used by several researchers in this literature. He raised a question mark on the measurement of this index, the economic techniques which have been used on it, and despite the fact that there has been a lot of a concern around this literature in terms of the construction of this index and it being used by other researchers, it has dominated the popular narrative and reinforced this widespread belief that rigid labor regulations have hurt the manufacturing sector. And this is actually despite the fact that there have been several other studies which have suggested otherwise, but they have captured the public imagination, or they have not been so prominent in the public discourse. For example, there is the work of Simon Deacon, who developed a leximetric data set on India's labor laws over the period 1970 to 2006. And he found that actually there was no evidence that pro-worker labor legislations led to unemployment or industrial stagnation. Then there was another paper by Emmanuel Teitelbaum, where he looked at the amendments in a more nuanced way, and instead of classifying them as being pro-worker or pro-employer, he classified them along the dimension of whether they increased or decreased government intervention in industrial development. And he found actually that more intervention resulted in higher industrial investment, output, and productivity. So there have been several papers that have questioned this belief of rigid labor laws having adverse economic outcomes. And there has been a question, as I said, about the codification of the Besley and Burgess index. But the question is not just about how that index was created. The question is also about labor laws, what they are de jure and what they are de facto. And we know from the work of, in fact, from the work of Professor SHYAM Sundar, and he says that the labor laws are not even a paper tiger. And in fact, if we look at various trends in the manufacturing sector, these seem to suggest that this in fact is the case. For example, we find that factories which have more than 100 workers, by Chapter 5B of the Industrial Disputes Act, have exhibited higher growth and variability of employment compared to other factories. We find that there has been a sharp decrease in the share of wages in value added in India since the 1980s, and wage growth has in fact lagged productivity growth. We find that an increasingly large number of regular workers actually have no written contracts. They have no vision to social security. In 2017-18, data on employment tells us that about 70% of regular workers in India actually had no written contracts, and 50% were not even eligible for social security benefits. So, the precarity and the vulnerability of India's workforce, the question about labor laws being very, in fact, excessively protected, it doesn't. The other issue I want to flag is that not only have we seen these trends, but increasingly firms have resorted to management strategies to circumvent regulations. And again, Professor Shyam Sundar has done a lot of work on this, where he shows that firms have resorted to outsourcing of activities by creating a supply chain which covers unregistered enterprises and even home-based workers. Then short-term contracts with breaks to avoid legal claim to permanency have been introduced. Then workers have been promoted to managerial cadre with job control simply to remove them from their bargainable position. The other trend, which has been very rampant, which has also been done to circumvent labor regulations, is the increasing contractualization of the workforce in the formal sector. And the manufacturing sector, actually, if we look at the data of the increase that we have seen in employment over the last 15, 16 years, over half of it has been driven by the growth of contract workers. Or this excessive contractualization of the workforce has been particularly severe in large capital-intensive industries and large labor-intensive industries. And this is a bit puzzling, because if labor regulations in fact bite labor-intensive industries more, then why is it capital-intensive industries have resorted to so much contractualization? And in some of the research that I've done with the context, the main motive that firms resorted, the main motive as to why firms resorted to increasing contractualization was basically a profit motive. The fact, and I think Kristen referred to this, and I didn't catch her entire presentation, but the fact that having contract workers basically allows, they do the same work as their regular or permanent workers, but they're paid considerably lower wages. Firms also don't have to bear the cost of social security which is associated with these workers. So therefore, the direct cost to the firm gets reduced by having more contract workers. But what I also found was there was another motive for which firms were using contract workers, which was that the presence of contract workers in the firm's workforce acted as an alternative workforce to suppress the bargaining power of their regular unionized workers. And for this reason, actually, if you look at the data again for the last 15, 16 years, you will find that the real wage growth of directly employed workers in the organized manufacturing sector has basically, and the presence of these contract workers has helped to suppress the bargaining power of these workers. Now, to the extent that labor regulations actually bite and hurt industry, it's worth citing one survey that the World Bank did way back in 2014, where they asked employers what were their main irritants, what were their and surprisingly, labor regulations did not actually feature any. And this is because companies actually base their investment decisions not simply on depending on how rigid or inflexible laws are, but on a range of other factors. The availability of decent infrastructure, efficient logistics, a vibrant domestic market, transparent official procedures, stable law and order, and more importantly, a healthy, educated, and productive workforce. Look at the literature New Economic Geography, which has been done on India, that suggests that industrial development at the regional level has been determined by factors like local educational levels, financial and physical infrastructure, the density and diversity of existing local industrial agglomerations and buy and sell networks, as well as access to large markets in urban centers. So what I'm trying to tell you with this is that the idea that it is labor regulations alone which have to the manufacturing sector actually doesn't bite in the context of all this evidence. And a glaring example of this is if we look at the amendments to the Act, which happened way back in 2014 in the states of Rajasthan and Maharashtra and Madhya Pradesh, where the IBA Chapter 5B was the threshold to which it was the threshold of firm size to which it was applied was increased from 100 to 300, Since then, we have actually seen no evidence to suggest that there is increased investment or employment gains in either of these states.
Radhika, 2 minutes.
So the role of labor market regulations, actually, in particular the hire and fire regulations, perhaps more modest than the intensity of the debate suggests. But the issue I want to flag before I conclude is that to say that labor reform is extremely important, but this has to be seen in the backdrop of the fact that over 90% of India's workforce is in the informal sector. It is outside the ambit of any social security provisions. It is left largely unprotected against arbitrary actions of employers. And therefore, the idea for this labor reform debate to be actually positive, as many speakers before me have said, it is important to move this discussion beyond the narrow issue of flexibility, beyond the narrow issue of hire and fire in Chapter 5 of the Disputes Act, to macroeconomic issues like a minimum set of conditions of work to all workers, a minimum level of social security, better and efficient labor administrative machinery, and a simple and fast responsive grievance redressal mechanism. And unfortunately, I don't have time to go into this, but the codes that we are seeing as they are being, the 4 codes, the process of being put forward don't seem to take us any closer to this agenda. In fact, it's deeply distressing that at this point, in the face of the pandemic and then the lockdown, when the vulnerabilities and precarities of workers have been acted like never before, we are actually raising questions on whether we should have labor regulations. The very existence of regulations is being questioned by the nature of the steps that are being taken by the state. This is really surprising, and I think it's important for us to go back to the drawing board and understand that why do we have labor legislations to begin with? The original intention of these labor regulations was essentially to balance the interests of labor and capital and correct bargaining power in a labor surplus country where labor is a less powerful party. Now, the reforms as we are seeing right now, not reforms, but the changes rather that we are seeing right now, because first objective, they have been all about reducing labor costs. But the labor reform should be about improving worker well-being, about improving productivity, making labor markets more secure, and that is what will make the economy robust. An unhealthy set of people working in exploitative conditions cannot deliver high productivity, and they can certainly not make India a manufacturing powerhouse. Not only are these changes just, legal, unjust, or legally questionable, as RAMAPRIYA told us, but the economic rationale of these, of reducing labor costs, reducing the share of wages in output, makes economic sense at a time when growth is slowing, when it is in fact going to turn negative, where domestic demand is so weak, and we know that external demand, in particular exports, cannot be an important driver of demand. So given the avenues of export-led industrialization are perhaps limited in the medium term in the wake of the pandemic, we need to focus on how we can enhance domestic demand. So steps to reduce wages and wage share of income are not going to take us, are not going to help us in the crisis. So just to conclude, I think that this low road to industrialization, as even Professor referred to, will not lead to development itself. It is just going to lead us to being stuck in a low-level equilibrium, which is characterized by increased poverty and tremendous inequality. Thank you.
Thank you very much, Professor Radhika, for that wonderful presentation of giving us the critical review of literature. Now we will go to the question and answer. First, I'll start with the questions for Advocate RAMAPRIYA. There are 4 questions to you, and the first one is that with the total abandonment of and violation of Constitution, the larger population seems to be silent. How do we respond? What should be the right response from active citizens? Question number 2, keeping in mind the vulnerability of migrant workers, especially the women workers, what can be done to mitigate their problems, especially as witnessed during the COVID times? Third one, given the declining this is also for Professor Radhika. Given the declining female labor force participation in India, what will be the impact of dilution of labor laws, and what will happen to their labor force participation in the time to come? So, and finally, to Ramapriya, under which law can one fix responsibility on the ruling dispensation, which has effectively destroyed lives and livelihoods of millions of workers, especially the unorganized workers? So, Advocate Ramapriya, could you respond to them? And then I'll take the questions for Christine and then Professor Radhika Kapoor.
Can you hear me now?
Yeah, we can hear you.
Okay, so I'll quickly respond to the 4 questions. Now, the first question was regarding the what should be the response from citizens to this exemption from labor laws and so on. My response to that is trade union rights and labor rights, they are democratic rights. So as democratic citizens, all the citizens of the country should be concerned about the infringement of these rights. It's not something that only workers should be concerned about. When there is an attack on workers' rights, it's also an attack on democratic rights. So it's something everyone should be concerned about. And to protect democratic rights, citizens need to stand in solidarity with workers at this critical time. Now, the second question was about the women migrant workers. What can be done to mitigate their problems? One is the Interstate Migrant Workers Act needs to be strengthened. The Act does not contain any provision specific to women migrant workers, and the Act has several shortcomings. The Act as it is has several shortcomings. Apart from the fact that it's not implemented, the legal framework itself has certain shortcomings. The law applies only to interstate migrant workers when they are recruited in numbers greater than 5 and when they are recruited in one state for deployment in another state. So it does not apply to migrant workers who are directly recruited in by the employer. So this recruitment of being recruited through a contractor and the numbers greater than 5, that itself restricts the coverage of the Act. So that is something, that's a shortcoming in the law which needs to be remedied. Secondly, this Act doesn't contain any provisions relating to social security for migrant workers. That is another shortcoming. So these shortcomings in the law need to be remedied. Now the draft code on occupational safety, health and working conditions proposed to subsume the Interstate Migrant Workmen Act into itself. But it much about contains the same provisions which are there in the Act at present. It doesn't make any improvement on the law. Only thing, it wants to introduce a wage ceiling in the definition of interstate migrant worker, which is not there in the law at present. And in fact, it whittles down one protective provision. Now, at present, interstate migrant workers are entitled to the same wages and same conditions of work as the regular workers in an establishment. They do the same or similar kind of work. There is no provision like that in the draft code on occupational safety and health and working conditions. The chapter on migrant workers and interstate migrant workers and contract labor, that's a common chapter. There's no exclusive chapter relating to migrant workers. So we should look at strengthening the rights of migrant workers. So, I mean, at present, the draft code on occupational safety and health and working conditions is not a law. So at present, the law is the Interstate Migrant Workers Act, and we should look at strengthening the Act to better protect the rights of interstate migrant workers and also women migrant workers. And also there needs to be a migrant workers policy in place, both at the central level and at the state level. Some states have good policy. For example, Kerala has a decent migrant workers policy, and so does Orissa. But other states also need to have these policies, and at the national level also, we need a strong migrant workers policy which will ensure adequate protection for the rights of women interstate migrant workers. Now, the third question was, can you just repeat the third question or just tell me what was
This is with regard to the female labor force participation.
Yes. Now, whether these labor law changes will have an impact, adverse impact on female labor force participation, yes, it will. One is with the increase in working hours. If the states are able to get away with this change and are actually able to enforce it and have 12 hours of work. Now, most of these notifications also say women workers will not be engaged between 6 p.m. and 7 a.m. So, which means that they will not want as many women workers on their rolls because they will not be able to engage them for 12 hours of work, unlike the male workers. So that is going to have an impact on the female labor force participation. And also because the provisions relating to women and children will continue to apply. They say even in those states where labor regulations are sought to be diluted now, I mean, in practical terms, like once the Maternity Benefits Act was amended, increasing the maternity leave to 26 weeks of paid leave, this has already had an impact even prior to COVID. Unfortunately, this move, which was aimed at strengthening women's rights, has led to women being terminated from their jobs and people being scared to hire women workers because they don't want to, pay them maternity benefits and so on. So, I mean, that was the case even prior to COVID. And now when they're looking at exploiting the workers by extending the working hours and so on, it will definitely have an adverse impact on female workforce participation, unfortunately. Now, the last question which was posed was, under what law can any responsibility be fixed on the ruling dispensation for the situation of the unorganized workers? Now, this is a difficult question to answer, but one needs to look at the Constitution. Now, the very preamble to the Constitution speaks about social and economic justice, and the directive principles of state policy, which the Supreme Court has said are supplementary and complementary to the fundamental rights. Although the directive principles are not enforceable as such, they stress on the need for social and economic justice for all, which would also mean coverage for all workers under the umbrella of labor laws. It would mean protection of the rights of all workers, including those in the informal economy or unorganized sectors workers, as we call them. So we can, I mean, it is very clear that the state has failed to act in conformity with the directive principles of state policy. And we can always make use of the fundamental rights read in conjunction with the directive principles of state policy when these issues come up for discussion before the courts. With a conjoint reading of Part 3 and Part 4 of the Constitution, the state can be made accountable.
Thank you. Professor Radhika Kapoor, would you like to come in? Your audio. Yeah. Yeah. Please.
So the question that was directed to me was about the declining female labor force participation, and RAMAPRIYA has already outlined all the legal provisions, and yet female labor force participation in India has been declining for multiple reasons over the years. One is the social and the cultural factors. Then there are not enough good jobs for women, and therefore women are getting rationed out of the workforce. And now provisions which actually extend working hours, it's going to become harder for women to get engaged. Also, if the costs to employers of hiring women, especially the social security in line with maternity benefits, are higher for women compared to men, then there will be a tendency for substituting women with men. And so then the pool of good jobs, the pool of available jobs for women will become even smaller, and we can expect them to continue withdrawing from the workforce. In addition to this, there is also the increased burden at this point on women of unpaid care work, of schooling children, taking care of the sick and the elderly at home. And all of these factors will eventually weaken away their productivity slowly. So definitely can expect to see declining female labor force participation. But having said that, we also need to flag that one of the reasons that female labor force participation in India we see statistically as being low And the child labor is also because of the way we measure work. And a lot of work that you do in the household is not actually counted as work in our national account statistics.
Thank you. Christian, the questions are for you. The first question is from Agnes Fiducia. The problem of child labor is quite worrisome, and during COVID times, many children have had to help their poor families by working. How is the situation of child labor in India? That is one. And
thank you.
No, wait.
Oh.
I'll give all the three questions and then you can. The second one is from Tina Flavia de Souza. Can the trade unions appeal to the Supreme Court for not consulting them before passing these ordinances in Uttar Pradesh? And there is a question from Anil Kumar. Trade unions are critical agencies of workers. Are trade unions losing their power in the labor market? And the fourth one from Mary Vimala Bai. Trade union rights have now become human rights. Can the trade unions take forward the legislative issues concerning the rights of child labor, child trafficking, migrant workers, unorganized workers, and informal workers? So over to you, Christine.
Yeah, thanks. First of all, on the problem of child labor, which has been asked by, I don't know, Ignacio, I think. Yeah. I think yesterday we had the Child Labor Day in India, called by the ILO and the Government of India. And it's
Kristen, you are both your video and audio are freezing.
But with the sorry?
Your both audio and video are freezing.
It's not working?
Yeah, now it's clear. Yeah. Please carry on.
Sorry. Yeah. Now, child labor in India, particularly post-COVID, is going to pose a very serious threat. We already have millions and millions of children, not only in factories, but also in very hazardous sectors. For example, the children in the mica mines. Those children have to be very young, very small framed to get into the pits of the mines underground. So they bring out the mica, which is sold for maybe 10 rupees to the child per kilo, but sold in much greater rate in the market. Now, post-COVID, the fear is because the lack of jobs is increasing, hence parents are now going to bring children to work. The second reason is because of educational institutions closed down, children were actually going there for free meal and for free food. Now that is stopped, and now children are back into the labor market. Now, during the COVID time and post-COVID, we will see a huge number of children coming now into the labor market, and largely it will be the girl child, because when you have dropout of young children from school, largely the first child to be removed from school is the girl child, and that girl child will now join her parents into the labor market. So dropout will be girl child, going into the labor market will be girl child. And we've also ratified the ILO Convention 138 and 182, but India has not really changed its laws to meet the minimum requirements of the 138 and 182. Now, if this is going to happen, we can see that more and more children in these COVID days will definitely enter the labor market. And since we do not have labor laws are going to be threatened, the labor inspection is under threat. We cannot have labor inspectors come to workplace where children are working because the new law ordinance is doing away with labor inspection, or is going to have self-inspection, and which employer is going to self-inspect and say, yes, I have child labor in my factory or in my enterprise. So for the problem of child labor is going to increase. It's going to be more, it's really going to be a big crisis where children are going to be, where children are concerned. And we feel it's largely going to affect the girl child. And now we'll find another generation of young children who will be future workers, undernourished, malnourished, and very, very weak. And most of them are showing signs already of tuberculosis. So this is the next generation of the workforce we are going to have in this country. So that's for child labor. And the earlier question which RAMAPRIYA answered, the media has to come out and discuss this. The media has to come out and talk about it. These have to be national issues. These child labor issues cannot only be issues pertaining to the trade unions. These are issues of the government as well. And here we have to partner with the trade unions, with the media, with civil society, and with NGOs to make child labor issue a national issue and a global issue also. The other question was trade unions are not consulted, right, Shyam?
Yeah. Can the trade unions go to the Supreme Court for not consulting them?
Recently, there has been a lot of action by all the national trade union centers. They have complained. They have taken case to this because the government is not responding. The state governments are not responding. The national government is not responding. Today, what's happening to seek solace and to get some national attention, the trade unions have approached the courts and taken their issues forward to the court. And in some cases, we can see that now they are looking at these issues and certain ordinances have been withdrawn because it's in violation of the Constitution, it's in violation of the ILO conventions and also of the national laws. So they are consulting them, and that is work in progress as of today. Human rights. What was the last one? Take forward child labor.
No, are trade unions losing power in the labor markets?
Sorry?
Are trade unions losing power in the labor markets?
Okay. Yeah, I think this is a very interesting question. If you see over the years, the trade unions largely did organize, had their presence in 8% of the workforce, which is in the organized sector. Later on, when we saw the workers in the organized sector are also getting into contract work, and many of them are now become incorporated as subcontractors and subcontractors. Now, what is happening is, if a permanent workforce is now being broken down into various sectors and also into the companies getting into different parts of contracting. For example, security or lift man or whatever it is it takes in a company. Now, these are being contracted out, which means they are now becoming informal. The contractors in their contract with the company do not give you the benefit which the principal employer will give to their permanent staff. And hence, even the organized sector, the 8% which the unions were focused on, is now moving into the unorganized sector. Now, again, if India's organized sector, unorganized sector is 94%, which means those workers are earning $1 to $2 a day, it's very, very difficult, the kind of percentage in India, the workforce, to bring them into the trade union fold. Now, if you say an example of the construction workers, if there's a wage negotiation, say my members of the construction sector is 20,000, but when I negotiate the minimum wage, it's not only and I increase the minimum wage, that increase does not only affect the organized workers of construction workers in the trade union, it has a wide coverage, and it also covers the wages of the unorganized construction workers who will also get the benefit of a wage negotiation done by the union. So the membership in the trade union may be small, But the coverage of that collective bargaining agreement or the wage revised wage agreement covers all the construction workers in the country. So the coverage
little
is
faster.
huge.
Question for Professor Kapoor also.
So the coverage is very huge, and that is why we can see that it also organizes in a way the unorganized workers. Today, the informal economy is also getting organized by the national trade union centers, because we can see that there's a lot of potential in that area. But the struggle is those informal economy workers are working under very, very precarious conditions. No contract, no housing, no education, no maternity, nothing. So the fight is very huge. And I think this is another area where the general public should also understand the struggles of organizing this group of workers. Okay.
Thank you, Christine.
The other thing, but very quickly, the media always demonizes trade unions. And I think this is what we have to relook at.
Right. Professor Kapoor, there are 3 questions to you, 3 or even 4. One is that, what about the labor laws in states like Kerala and West Bengal, which have been governed by communist parties, and they must have had a pro-labor orientation. So how would you connect this with their economic performance? That is one. And the second one is from, that was from Selvaraj Arulnathan. Second one is from Shiny Joseph. The economic survey, one after the other, particularly the previous one, argued that the amendments made by Rajasthan government in 2014, in fact, yielded benevolent labor market outcomes. So what would be your take on that? Would you agree with the kind of analysis done by in the economic survey? And then there is a question by Sai Leela Modam. If contract workers incidence is increasing, as you have highlighted, would it not affect productivity adversely? And then is it a economically rational labor market strategy by employers? And finally, there is a political economy question. If the scientific evidence is rather weak, as you have argued very succinctly, why do reforms take place? The kind that we see. Okay. So over to you, Professor Kapoor.
Okay. So to go back, I mean, when you look at this statewide analysis of what distinguishes the performance of states, particularly in the context of their manufacturing sector, there is, as I said, in addition to labor regulations, there is a whole set of other factors which range from things like having efficient logistics, having quality infrastructure, credit. There are credit issues. There is the existence of local and urban agglomerations. So one cannot simply restrict a comparison of the states on the basis of the labor regulatory environment, and that's the point that I was trying to make. And then, if you look at there, it's also true that some of the most educated states, there are a larger proportion of the workforce there is in fact engaged in the services sector. Because what happens is also that the composition of the workforce in terms of education in many ways will determine the structural transformation process that state undergoes. So some of the states like Kerala, you actually have a higher proportion of the workforce which is engaged in services simply because it is a more literate state. So reducing the comparison across states by looking at simply the nature of the labor regulatory regime is just is sort of inadequate. And in fact, this is also one of the critiques of the Besney-Burgess paper, that the control measures, the control variables that were used in that analysis actually overlooked a number of these factors. So I wouldn't want to restrict it to that. On the question on Rajasthan and Madhya Pradesh, now this was the economic survey that came out last year, and the point is that that I don't know how technically or non-technically you want me to answer this question, but basically that analysis was based on aggregates at the state. What were the total number of factories? What was the total number of employment? And a bunch of variables that are in the annual survey of industries data. And it was based basically on just about 190 or 200 observations from what I recall. Now, to actually understand conclusively what the impact of the amendment in increasing the threshold from 100 to 300 workers has been, one actually needs to look at analysis, and that's not what the economic survey did. In fact, this is one of the other points I wanted to make during the course of my presentation, was that at the point when this entire empirical literature was developing, we didn't have a firm or establishment or factory level data. We used to use aggregates at the state level. But to actually meaningfully understand what is happening, how firms use different sorts of management techniques to circumvent regulations, one needs firm level data. So the analysis was there in the economic survey, and let me say it was just very preliminary at best using state level aggregates. And I would say that unless their result is corroborated by firm level findings, I wouldn't, attach too much to it at this point. In fact, looking at CMIE data, which talks about state level investments, there's nothing to suggest that more investment again flew into these states simply because the threshold of IDA was increased to 100 workers. The question on the productivity, the impact of contractualization on productivity, is actually a very, very interesting one. It is more interesting in light of the stylized fact that actually there is more contractualization which is happening in capital intensive industries. And these are industries where you would imagine that you would need more skilled workers. So why is it that firms are resorting to increasing contractualization here? I mean, that's not something which is entirely clear, and it's something that I'm working on in terms of the data to understand what the impact of that on firm level productivity is. But the evidence at this point doesn't seem to suggest that there is too much of an adverse impact on productivity. But the question therefore really is that when the firms think of these techniques which help to reduce labor costs, the focus is simply on reducing labor costs and increasing the share of profits in gross value added. It is not about improving well-being or enhancing their productivity and improving firm level productivity. So therefore, definitely, maybe in the short run, it is difficult to understand why this is happening. But in the long run, it would be reasonable to assume that this would not only have an impact on firm productivity, but also in firms where a worker will not be interested in investing in firm-specific capital, because if they know that their contracts are going to be of a certain duration, and a few years down the line they would be looking for employment in some other firms, given the precarious nature of their contract, even firm-specific human capital formation is not going to happen. And on the final question, I mean, this is on when the scientific evidence in fact is weak, why do we see these so-called reforms taking place? I mean, the answer to that is something which I don't think I alone can answer, because it is indeed that, I mean, despite this, at least in the academic circles now, there is increasing recognition of the fact that the scientific evidence is weak. The popular narrative has been one of laws having hurt manufacturing growth. And in fact, some of the recent amendments, not the amendments, but actually the relaxations which have been given by several state governments have shocked even some leading proponents of these flexibility studies, who have argued that India needs more flexible labor laws. And they also said that, we talked about things like hire and fire. We didn't say that factories have to be exempt from all labor laws. So I think perhaps a lot of this is also just posturing, because there is this widespread belief that the labor regulations are rigid. It's something that we can be seen as doing proactively in the short term, because in terms of attracting firms, we've given them tax concessions. There have been fiscal steps on the fiscal side, on the monetary side, and both have not yielded any returns so far. So perhaps this is the next in line where we can say that we took this immediate action, and investment will probably still come in, because at the end of it, investors are not looking for a low productivity, unhealthy, low literacy level workforce. I mean, they need a productive workforce, which comes from investments in human capital formation, in health and education, which we have not done over a long period of time. So this is like a low route to industrialization that we are trying to take to somehow attract investment, which is really not going to yield any returns.
Thank you. Thank you, Professor Kapoor. And ladies and gentlemen, we are drawing close to this wonderful webinar, and I apologize on behalf of everyone that there have been some technical glitches, but these are expected hazards in any webinar, and the panelists have tried their best, and the ISI Institute has done their best in order to coordinate as efficiently as possible. Now it's time to wrap up. I'll just take 3 or 4 minutes to just convey the main takeaways of the webinar. Advocate Ramapriya Gopalakrishnan has very succinctly and analytically laid down the various aspects of changes that have been brought in the name of flexibility by various state governments. She has clearly shown that these labor law changes are antithetical, or they militate against the Constitution of India and the ILO treaties. The kind of the entire presentation of us show the complete absence of, or even destroying the fabric of industrial democracy that has been so painfully built over the decades. That brings us to the question of the role of trade unions, who have, the trade union movement has sought to be inclusive. That is what Christine argues. And trade unions have never fought shy of social dialogue. Trade unions over decades have constructed the body of labor rights, and they are in trouble. Trade unions cannot be blamed. Trade unions are keen for dialogue. Trade unions are conscious of the responsibilities. And in fact, they have become far more inclusive than they were. And they are responding to the globalization forces as they should. And of course, Christine has spoken of the various social issues that still remain on the agenda of trade unions, so to say. And from the entire the tone and contents of Christine's presentation, it becomes very clear that trade unions have begun to be thinking organizations. They are not merely protesting organizations; they are thinking organizations, and they are also having their own self-interrogations. And Professor Radhika Kapoor has used a little bit of technical literature, and I should really congratulate her for making it as simple as possible to convey the technical conversations into a manageably understandable delivery, in order to show that there is very little scientific evidence to say that labor regulations are the major problem or even a minor problem that discourages foreign investors to open their shops in India, or it is affecting industrial growth, or prevents employment generation, etc. The main point that she showed very clearly that there are serious problems not only with the academics, but also in the way the industrial sector in particular and the labor market in general have been responding in terms of various metrics that she has shown, like proportion of contract workers, or the preponderance of contract workers in the capital intensive industries, and so on and so forth, to say that the employers' labor market strategies need to be interrogated as well. This is a very important dimension that Professor Radhika Kapoor has brought on the table. It is not only the government policies, but also the labor market and industrial product market strategies that the employers have been following, which she has distilled from the government data themselves, and thereby bringing a new dimension to the debate that the trade unions, the advocates, will need to take these kind of labor market data evidence in order to take forward their battle against the kind of neoliberal labor law reforms that are taking place. And I think this is a very valuable addition from an economist of her repute. And all in all, these three conversations have shown that India is moving quickly and surely far away from the glorious institutional constitution and ILO framework driven labor market management or industrial relation system governance to that of neoliberal kind of labor regulation regime in particular, and neoliberal regulation of economy in general. I think these conversations will be continued in various forums, and the battle is on for the academics, for the advocates, and the trade union leaders. With these concluding remarks, I bring the webinar to a close. But before I close, I would like to say that on behalf of ISI, please continue to support #We4Migrants campaign on Twitter, Facebook, Instagram. Last but not the least, I should take this opportunity to thank ISI and their excellent technical and administrative and managerial team to put together this wonderful webinar. And we wish, on behalf of the panelists and on my personal behalf, I thank the Institute and the organizers. With this, I close this webinar with thanks to one and all, and particularly those people who, all people who registered and who have been patient to listen to all these panelist remarks and my remarks. Thank you very much to one and all. Good night. Wish you a safe India. Thanks.